Okay, we are live. This is Attorney Vince Davis, and this is The Secret, How to Fight CPS and Win. I'm joined by my very special co-host, Miss Deidre Payne. Miss Payne, how are you?
I'm good, thank you.
Don't forget we can't see you. And we have a very special guest tonight, Miss Charlene Strang. Is that it?
Yes, sir.
How are you?
I'm good, sir. How are you?
Good. You can just call me Vince. Sir, you don't
Okay.
have to use. Okay?
I'll try.
Okay. So, Charlene, where are you calling us from?
I'm calling from Butte County, California.
Oh, okay. You're right here in California.
Yeah.
Okay. So what's going on with CPS in Butte County?
Right now, we're getting ready to go back in for the 6-month review. So I had wrote down some questions that I thought were good for me to get clarification on, and also questions that I felt that were questions I would have known to ask ahead before I got to this point that maybe
Okay, go
might
ahead.
help. Okay. I wanted to kind of get an idea on exactly what discovery is, because it seems that there's some sort of a base. I mean, I know like there's certain things that are in a discovery, but are there certain things that seem to be that aren't there that should be there? Maybe.
You know, that's a difficult second part of the question. Let me tell you what discovery is, first of all. Discovery is this exchange of information that each party has accumulated through the process of this case. Let me give you an example. A lot of times, CPS social workers write in what they call the delivered service logs or Title 20s. It's really a diary of the case and of their investigation of every CPS worker that has touched the case. All right. Now, those, at least the way they do it in California, are computerized and sent back to Washington, D.C., to the Department of Health and Human Services, who uses those delivered service logs to audit the work of the CPS agent in California for purposes of financial, pay, and also for making sure that the CPS agent is complying with federal regulations or federal law. You see, there's a whole bunch of regulations that are developed by the Department of Health and Human Services on how CPS agents must act in every state. And they must act this way and follow these regulations if they're going to receive federal money. Okay. So those delivered service logs are computerized. They're sent back they're stored and they're sent back periodically to Washington, D.C. Now, the
Okay.
interesting thing is in delivered service logs, you sometimes find what is called exculpatory evidence, which means evidence that is good for the parent.
Hmm.
And they just never put it in the social worker report because they either didn't want the judge to know it for whatever reason, or they didn't want you to know it. Okay.
Okay.
And,
And
because sometimes the exculpatory information is a statement made by a witness, a statement made by, or conclusion made by the social worker, or the fact that there was a witness to an event that you just didn't know about.
okay.
Okay.
Now, what what happens when you request for discovery and certain um items are not in the discovery that you feel should be?
Okay. Well, the should be is kind of hard to prove, right?
Okay.
Uh, but you can make a motion to compel discovery under the California Rules of Court.
Okay.
And I think it's 5.546 or something like that. It's 5.5 something if you just go and look at a table of contents on Google for the California Rules of Court. You want to look at Rule 5.5 something, and it deals with discovery in CPS cases.
Okay.
Now, there's an ultimate penalty for them keeping discovery away from you. And I don't see it used often, but if you find out or show that, or the social worker admits that they don't give you all the discovery that you're requesting, you can make a motion to have the case thrown out,
Okay.
to have it dismissed.
Okay.
More times than not, though, if that's the situation and your attorney are um, working hard and bold enough to make a motion to compel, the judge will just order that the social worker compel with the discovery. I've made this motion, a few times, many times over my career, and rarely is it granted to have the case dismissed.
Right.
Instead, it's granted to continue for you to get the information.
What's
I have a
the,
case. I have a case
okay.
right now where that's an issue. Go ahead. What was what?
I was wondering what the difference was between what they call the mother's statement and a declaration.
A declaration in California is defined as a typed statement that's signed under penalty of perjury.
And what is the parent statement? What's
That's
that?
just something that the social worker records in her report, writes in her report based upon her recollection of, conversation with the mother, or the policeman's conversation with the mother, or another social worker's conversation with the mother. That's the mother's statement. The mother's not swearing under penalty of perjury like in a declaration that what the social worker is saying is true. As a matter of fact, a lot of times the social worker statement is not 100% correct.
Right.
I want you to, they do all kinds of studies, psychological studies. Let's say you and I have a conversation right now. In, 6 hours from now, when you're back at the office, you decide to summarize our conversation. It's, unless you have a photographic memory, which not everyone does, you're not going to get the conversation exactly correct. So you notice a lot of times parents will say, I never said that to the social worker, or it's twisted a little bit, Mr. Davis, from what I said, or it's taken out of context. Now, all of those things are either deliberate misrepresentations by the social worker, or it's just the social worker's bad memory, her bad recollection. Okay. That's why I'm an advocate of, these social workers should be using body cams.
Yeah.
So you don't have to argue with the judge. Judge, I didn't tell her that. I didn't say I used heroin right before the birth.
No.
I said I used heroin 3 months before the birth, or before I got pregnant. It's funny how, the statements are they're twisted a little bit. And then, the social workers, more times than not, their statement or their report is taken it as if it was the word of God, and it's not. And that's why I think you should use body cams. Now, here's something I've done in some cases, not all. I've told my client, hey, just record the conversation. Now, it's illegal unless you get the social worker's permission.
Right.
But in California, you have to give them that warning, and they say, well, no, I don't want to talk to you. And then my position is, well, they could have talked to my client. My client was just recording everything. What does she have to be worried about to be
Yeah.
recorded?
I've done
Don't
that.
say I didn't. Don't say I didn't cooperate. I tried to cooperate,
Yeah.
and the social worker just didn't want to be taped. That's on her, not on me.
Right.
Next question.
Okay. What are the benefits of testifying? I know I've heard all the do's, the don'ts of not to, but what are the benefits of testifying?
Well, I'm going to talk about benefits because there are some burdens, but I'll just talk about the benefits since you've asked that. The benefits are that you get to sit right next to the judge, in most cases, in the courtroom, look the judge in the eye, look the audience in the eye, and tell your story. If you don't testify, the social worker's story is the one that's going to control the entire case. Okay? Now, as long as those burdens don't outweigh the benefits, you should, in my opinion, get on the stand and tell your story. Sometimes the social worker will say, well, mom took counseling, domestic violence counseling, but she didn't get anything out of it. right? So
Mhm.
sometimes I put my client on the stand and say, hey, Charlene, you took domestic violence counseling? Yeah. How many times did you go? I went for 52 weeks for 1 hour each. And what did you learn? Well, I learned in chapter 1, blah, 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 blah. Chapter 2, blah, 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 blah. And here's the key. And then I'll ask you, hey, well, Charlene, how are you applying that in your life right now? Now, for the social worker to be correct that you're not benefiting from it, you have to say, well, I'm not applying it in my life. I don't think it's a good idea. Something like that. But if you tell the judge, well, you know what? I thought that chapter 1 was really informative. It really applied to me and my significant other. And this is what I'm using to make sure that we've changed. Now, the social worker, even if you tell the social worker that information, more times than not, she's not going to write it in the report to the judge. So who's going to tell the judge if you don't tell the judge? Not the attorney. Attorneys can't testify in trial. They can ask questions, but they can't testify. So you're the only person that can tell that story, and that's the main benefit, in my opinion, of you testifying.
All right. The next thing I wanted to kind of talk about, I was kind of just kind of get to the point. Can a dependency judge order you to test?
The answer is yes, depending on what time in the procedural timeline you're at. So,
Okay.
and you know what? My answer isn't really accurate.
Okay.
The judge can order you to test, but you don't have to. The
Okay.
problem is that 999 times out of 1,000, if you don't test clean, you're not going to get your children back.
And can I ask
You don't.
why?
I'm sorry?
Can I ask you why that is?
Because it's a court order, and the
Okay.
judge has determined that you have to do this in order to get your children back. And if you don't do it, it's going to be assumed in the law, especially here in California, that you are still a risk to the child. That's
What
why
happens? Oh, sorry. Go ahead.
that's why the first part of the case is so important, so that you can argue and present evidence as to why you shouldn't have to do a certain thing in the reunification plan. Like, well,
Okay.
Judge, I've seen cases where drugs aren't even an issue,
Right.
and the judge and the social worker say we want mom to test. Like, where does that come from? It happened to me one time. I remember this happening to me, and I had an argument with back and forth with the other attorneys and the judge, and I guess the judge thought that I was felt strongly about it and maybe would appeal it. But the social worker was asking for drug testing for my client. There were no issues about drugs or alcohol. And the judge, who I think wanted to order it, decided not to order it. You just can't order anything at the disposition hearing. It has to be narrowly tailored to what the problem that brought the family to court.
What
Right?
happens when you go to your 6-month review and you're not allowed to talk about anything prior?
Okay, what happens? I mean, you just stated the law. What do you mean what happens?
Because my understanding, the 6-month review was to see if we had ameliorated the reasons that brought our family under the jurisdiction of the court.
Correct.
But
And
we
you
are
know
not
what?
allowed to talk about anything pre-jurisdiction.
Correct. That's the general rule. I'm sure there are some exceptions. But look, you went to the jurisdictional and dispositional hearing, and if you didn't get your kids back, it's over. It's done. You have to appeal. And if
Yeah,
you
we're in
don't
appeal.
appeal, or if you don't appeal, or if you appeal and you don't win, you're stuck with the judge's orders. Period. End of story. That's just
Okay.
it. So when you
So,
come back for the 6-month hearing, the only thing the judge is interested in is, did you do your programs? Did you do your plan? And did you benefit from it? That's it.
um,
Whether the original allegations were true or not, that's over.
okay.
Unfortunately, that's over.
Okay. What happens when you've been cleared of needing services through the Health and Human Services through the state of California, and they continue, but yet you're told you have to continue services anyway through.
Wait. Say that again. I didn't follow you.
If you've been cleared from Health and Human Services from the state of California, you've been cleared. You don't need services. You're fine, but yet they still want to tell you you need services.
Okay, I don't follow that. If CPS tells you you've been cleared and you've done everything, then who's going to tell you you still have to do something?
The social worker and the judge.
Well, who cleared you?
Um, Butte County Behavioral Health, they cleared me for needing services.
Okay, was that the CPS worker?
No.
Okay.
That's they send you out for an assessment. They want you to have an assessment done. You get
Okay.
it's like all the counselors, head counselors, and they're above social services, but and they had an assessment. And I had one done previously before all this, and then a month prior, and then I had another one done in December. And they said, no, Charlene. I told them everything going on, and they said, no, Charlene, you're fine. And then they gave me the documentations, and I filed them, but they didn't change anything.
Okay, so let me tell you why. I'm going to tell you why.
Okay.
This is one of those things that fall under, if you try to figure its common sense, you're going to be frustrated and confused, because this is not common sense, in my opinion. An outside counselor can say, hey, Charlene, you don't need services. But the judge could say, Charlene, I disagree with that outside counselor. Here's why. And I think you still need services, and I order that you still do the services. That's how that's played out. The judge is the final arbiter. Anything he or she says, that's what goes in the courtroom. Now, here's what you should ask yourself. If the judge does that, when the outside vendor said, you don't need any more services, and the judge rules against you, the first thing you should do is visit the clerk's office. We'll talk to your attorney, of course, but then visit the clerk's office and file a notice of appeal.
Yeah, we're in appeal right now, so.
Well, no. This is an appeal of the 6-month hearing. You're in an appeal for the disposition hearing. Totally different.
Yeah.
The Court of Appeals isn't going to address what happened at your 6-month review hearing while they're doing the disposition hearing, unless you file another appeal and combine them somehow together.
Okay. All right. And then let's see what else was I going to ask you. Transcripts. I know that was a really confusing part for me. I was just hoping you could explain how that whole thing works when it comes to the end.
When it comes to what?
To the end of the hearing, about to be able to how you obtain them.
Oh, you have to go to the clerk's office. You file a request for transcripts. Because it's a confidential case, you're going to have to they're going to have to get the judge's approval. Okay. Now, if the judge says no, you should appeal it. In my opinion, in most cases, you have an automatic right to get your transcripts. That's like getting your minute orders and your court reports. Because sometimes mistakes are made, and transcripts can prove that the judge said something or didn't order this or didn't order that. In many cases, I hear a lot of times, the judge will order 1, 2, 3, and then when you go talk to the social worker the next week, she says, oh, the judge said 1, 2, 3, 4, and 5. And you're like scratching your head. No, the judge didn't say 4 and 5. And the worker goes, yeah, he did. He said 4 and 5. The only way that you can fix that is by ordering the transcript to show the judge didn't say 4 and 5. You added 4 and 5 just because you wanted to, or you were misinformed.
Let me see, which was the next one here. So let's say that you what if a judge advises you to test?
That's a tricky question, Charlene. If it's me, I test.
Okay.
Technically, if he or she advises you to test, you could argue that that's not really a court order. And maybe you or your attorney should ask for clarification from the judge, not from the social worker.
Right. So, say a judge or advises you to test, and you do know your rights, and you object, kindly object, and then come another hearing, the same thing, advises you kindly, and you kindly object and state why, and then it comes to the point where you get ordered to, and you object. What happens when you go, and then you go back to court one last time, and you get told ordered to test? You object, and now you're getting ready to go back for a third time. What is the worst case scenario here?
You don't get your kids because you didn't test.
Okay. Now I got to ask you a hypothetical question, just because I really want to understand this. So, Mr. Davis, if you were my attorney, sir, and I tested for you, but not the judge, and so you know I'm solid, does that change anything for my lawyer?
I know you're what?
Does that change anything for my lawyer to I'm not sure how that would work out. I think my biggest concern is, so I go in
No.
okay, go ahead.
Stop. Okay. You were doing great with your questions.
I know, I'm sorry.
No, you were
Curveball in
doing-
there. I was waiting
no,
for it. Sorry, go ahead.
I wanted to say you were like the most prepared guest I think we've had in a long time.
ever had. Okay,
Yeah,
but Charlie,
really,
Okay.
honestly.
I want you to start over and
Okay.
ask me that hypothetical question.
Okay.
Okay, speak clearly and slowly and ask it just like you want to ask it.
Okay. If you were my attorney, sir, and I've
Mhm.
tested for you, and then we're getting ready to go into court, and they say you got to test, and you test, and you can have your kids back, okay? And you know you've been good this whole time, so you test, but all that time that I've not had them, all because they didn't have something in a cup. But I haven't changed, nothing's changed. So it's just, is that really going to help the next family? What if I say no? No, you can't violate my rights no more. I've had enough. I've watched so many children be ripped from their parents' arms. This is wrong. What if I say no this time?
Okay, hold on a second. Hold on. I'm still not clear on the question. Deirdre, can you
I
help me
think
out?
what she's trying to say is if they were to basically say that you getting your kids back is going to ride on this one last UA right now, and you don't want to do it. She's basically asking you, why can't she have that right to finally say, I've been testing all this time and I still didn't get my kids back. Why is this one last test basically
I
going to
got
make me a burden?
I got it. Mr. Guai,
Yes, sir.
you were giving me the finger.
Yes, because we both know that I've showed you before, right? And those things. FAFSA states that you cannot use a urine screen on its own to determine whether or not you are able to terminate parental rights, to decide whether visitation is determined on that. Like if you've been going to counseling and all these other things and you've been doing these, a urine screen cannot dictate whether you can see your kids or whether they can terminate your rights. So I don't understand why this is becoming an issue when people are denying, like, no, I'm not going to do the urine screen, but I went to counseling and my counselor says I'm fine. It says it right in the FAFSA rules. You can't do that. It cannot happen. All of the rules for every state, I believe, do that.
I think it goes back to what Mr. Davis said, though, in the beginning. If you don't object to it in the beginning, now you have no other choice, right?
So, Charlene, I'm going to give you the answer to that question.
Okay.
There's two answers, actually. Okay. And what really happens is going to be based upon your case, the nature and the procedural matters, the relationship you have with the judge, etc. Okay. if a judge, and you know what, I've seen this happen, by the way. I've actually seen something like that happen in courts a few times over the years. You can object and still take the test. You can object and not take the test, and you can object, excuse me, and you can just take the test without objecting. Okay? What you are doing is standing on principle for your rights.
But
And
they're not just mine.
well, I commend you. However, as I've said many times, do you want to be right or do you want to win your kids back? You can only have one.
If I, but if I fight for what's right, then it helps the next person.
Hey,
Oh
If I
no,
fight for
But
what
you
no.
lose your
to
kids.
win,
no,
How about
then
this?
no,
How
no,
about this?
no,
How about
no, no, no,
no,
no,
or is it the other
no.
way
listen?
around?
Hey, I fought for our rights. I fought for our rights. I lost. You get your kid back, please. I'll take the
Yeah.
triumph. I refused the urine screens. I did that. I fought for our rights. Okay, I
This is
did
like
it.
a repeat of last night's show with the same
Urine screen.
idea. Meaning,
Back, go get that urine screen. I already took this fight up. Please go get
go
your urine
test.
screen.
I have
96%, 96%
Please
weight.
go get your kid. Go get your
Charlene,
kid.
yeah,
I
yes,
lost
Charlene,
my kid
sir.
because I did
Yes,
that.
sir.
Charlene, you did you hear what Darren said?
Yeah, I
He lost
know.
he lost his kids because he did that. Now,
Well, right now we have.
you know,
Okay, go
but
ahead.
hold on, let me finish.
No,
Let me
oh,
finish.
go ahead.
You know, one of the reasons why I have co-hosts like Darren, like Deidre, like Miss G, is because they've been through it.
Yeah.
They've been through the grinder.
Can I
Okay.
just say one thing real quick? I don't mean to interrupt you, and I don't mean to be rude, but I have somebody who is very special to me. It's my husband, and my husband actually has already went through all this before, and he lost one, and he has been fighting by my side, and this man is amazing, and we actually went and he studied so hard for this last year, but he went and he filed the 1983 in the federal courts, and so he's unbelievably one of probably the smartest men I've ever met in my life. I've never seen anybody excel. Um, I mean, it's a bit much. It's not something we wanted to do. We tried really hard to work with everybody here and just our community to try to to make a difference and to do things in a better way. So we're just it's we've got the appeal going, plus we have the 1983, and I mean it's um we are great parents, and we should have never been put in the situation now that we are, and it's kind of like God's given us an opportunity where we're in a position where we can stand up and say something, and it's been hard, don't get me wrong. It's been parental death without mine, but I've done all the classes, even though they said it didn't have to. I was already in those classes before even ordered to. I mean, I have been dotting my I's and crossing my T's and doing up and beyond, but still standing up for myself, So and so we'll see. They've got I have my attorney now, and I'm a little hesitant, but at the same time, I'm not. Kind of smile because I think that God gave me gave me somebody who's actually who's gonna back us up. So this is kind of cool. We'll see. But
Is it a court appointed attorney?
uh yes.
Or did you hire him?
No. He's what I think he's kind of what do you call it? I think he's the underdog of the group. So I think
They haven't corrupted him yet?
no, he's I think I think he's gonna do exactly what what we've instructed. So I think it's
You
gonna
lost me. I'm confused.
it's
I want
gonna
to hear
be
what Mr.
okay.
Davis is saying.
I
want to
got a
hear
lot of
what
faith, man.
Davis
Either
is
way,
talking
God's
about.
got it, and I have a lot of faith. I do, big faith. So, but like I said, there were some questions I wanted to ask to clarify, like questions I really wish I would have known when the beginning of when all this started. You know what I mean? You have answered so many questions, Mr. Davis. We watch you constantly. Between you and Sean McMillan, man, you know, we look up to you guys. We really try to soak in as much as we can over the last year of our lives, and try to help other families with the information we do have. You know, and be supportive. This is tough. This is very tough. Very sad thing.
Sean is the guru, right, of
Yeah.
1983,
I know.
right?
He's got me on tomorrow night, so for office hours. So
So he has in the past um, given me training and instruction and information over the years. Um, so whatever he says, go with whatever he says. The only thing, and I always wondered this: Sean doesn't represent people in CPS courts, and he should. He would do really well. He would do really well. By
yeah.
the way, on our
He's going
seminar,
to be with us tomorrow?
no, he's not. I didn't ask him because
Oh no. He
it's
has
not
his
going to be
own.
it's not going to be anything related to 1983.
Yes.
We will one month have something on 1983, and I will give him a call and ask him. However, one of the CPS attorneys that Sean does work with is a guy by the name of Arthur J. Lasalento. And Mr. Lasalento is going to be one of our presenters tomorrow on our seminar.
Right on. That's cool. Yeah. He's got me tomorrow night on his office hours. You know, to more talk about the 1983, and I'll just throw that out there that if you're ever interested, Mr. Davis, we're looking. So we'll see.
Have
So
you
far,
talked
my
to
husband's
have you
going for her. Oh yeah,
have you
he's we've talked to him about it and stuff. Everything's kind of just we're in motion, so we'll see how this is gonna go. I would just wanted to touch base with you. Like I said, I know there's some questions and stuff that
there's another guy that Sean is really good friends with up in like the San Jose area. Has he
yeah,
mentioned his name? Yeah. Okay.
he gave us a name, so we're
Okay.
gonna we'll see how that plays out. So
Very good. Very good.
yeah.
Actually, there's two guys in San Jose. One of them is semi-retired, but one of them still has his firm open, going strong, representing people. Any other questions you had for me, Charlene?
Let's see. Here's one that might be helpful to understand for some and for me too. Can you explain what a general denial is?
Yeah, I do want to make something clear. It has nothing to do with your case right now. Okay.
Okay.
All right. At the beginning of the case, when you show up for the detention hearing, they used to call it the arraignment detention hearing. Now it's just the detention hearing. The judge wants to know, do you admit any of these facts in the petition, or do you deny? So the best practice is for you and your attorney on the very first day to enter a general denial to the allegations in the petition. Okay, unless a subsequent or amended petition is filed, the word general denial, that phrase, has nothing to do with your case. It's just where you are. It's like a criminal case when you show up to the first day, the arraignment, and the judge or the magistrate wants to know what's your plea, guilty or not guilty, and almost 999 times out of 1,000, the defendant says not guilty. Now, that's not going to come up again until the end of the trial, when the jury says guilty or not guilty. Right? But it has nothing to do with your case now. I just wanted to make sure you realize that. But but I hope that answers your question.
Yeah. Is it for the general denial? It's pretty. I was looking it up and it was saying it's you're denying the whole thing. as opposed to the line by line.
Correct.
Okay. So, and that would mean for detention that in order to do the line by line, you'd have to have the time to sit down and go line by line. And then is it true that you only have 24 hours to do that in?
No, but I think you might be mixing a couple concepts.
Okay.
When in California anyway, when they take your child, they have to take you to court within 48 to 72 hours.
Okay.
It's this 24-hour thing is not relevant or not accurate. Oh, I take that back. The 24 hours does come in when you show up at the detention hearing and you don't have enough time to prepare because they purposely don't serve you the paperwork a day or two before. They give it to you that morning. Here, you ready to go? Ready to do your case? You know, the detention package is like that big. You're like, come on, get serious. You can tell the judge, I want to continue it for 24 hours, one day, so that you and your attorney can prepare for the detention hearing.
Okay.
I mean, I've gotten detention packages sometimes, you know, that are so thick, I don't even try to read it. Judge, I want a continuance one day, automatic continuance. We'll see you tomorrow. Go back to my office and read this thing.
The other thing is I know California, it's getting really crunched for cases versus attorneys ratio here. Is there not a set limit for you guys that you can only have so many so you're not overwhelmed?
No.
The
The limit is what you should, as a professional, what your office can handle. Now, I will tell you this. There's kind of a famous case in the CPS world that's very rarely talked about. And I think it was out of Georgia or Mississippi, somewhere in the South. Somewhere in the South, the parents, I don't know if it was the parents or the child, sued the court-appointed attorney and said, by definition, you have too many cases and you cannot possibly represent me well. And it went before a 3-panel federal court, district court, trial court, 3 judges. And they decided in a written opinion for that particular county, and I think it was minors attorneys, that minors attorneys could only have X amount of cases. And the case went through testimony of experts of what it takes to represent a minor and, what type of investigation and how many hours in the day there are. You got to sleep 8, So that court specifically found in that county that minors attorneys can only have so many cases. Now, I think, because it's been a long time since I read the opinion, but I think the court said this is a rule based upon the evidence that we heard for this county. But if you're asking, should court-appointed attorneys have a limit? I would have to say yes. But I'll tell you this: when I was a court-appointed attorney 30 years ago, there were sometimes I had 400 or 500 cases.
That's crazy.
Jesus almighty.
Yeah, and there wasn't, or I don't know if there wasn't, but they didn't want to spend the money to hire more court-appointed attorneys. I don't know what the limits are now. I don't know if court-appointed attorneys have that many cases now. Probably not. But even if you have a caseload of 200, that's still a lot of cases.
Yeah,
Right?
I did a little research and I wasn't. They were talking like on the good amount, that study that you were just talking about. They did studies on, and they're saying about 140 that's good. That's helping. You know what I mean? It's but they start getting up in the 180s and it starts getting, it's not fair.
Mm-hmm.
So I don't know.
Well, it's not fair to you, right? And if you wanted to do something about it, you might want to look up that case, that federal case, and copy it and maybe file it in your county.
Okay. All right. I think he about answered all of my questions. Let me check here, make sure I didn't miss anything.
Mhm.
Yes, you did. That was it. Every time.
Well, very good. Well, I
Yes,
want to
thank
thank you
you.
very much, Charlene, for coming on, sharing a little bit of your story and asking those questions. You were very well prepared. Like
Yeah.
Ms. Payne said, you're probably the most prepared guest we've ever had. So kudos to you.
Thank you. Just
I wish
keep
you luck.
helping them and keeping
I
helping
wish
those
you
parents, man. They
I
need all
wish
the
you
help
luck.
we can get. Thank you.
Wish you luck at your 6-month review. When you see Mr. McMillan on Zoom, tell him that Vince Davis said hello.
I will,
All
sir.
right. All
You have
righty.
a blessed day. Thank you,
You
guys.
too. Bye bye.
Bye.
Bye-bye.
Go get
Well, folks, we have a few more minutes before the end of the show comes up. Ms. Payne, did you have any questions or comments that you wanted to add tonight?
I was just kind of curious how the flow of tomorrow was going to go because Grace said that you were wanting me to kind of join you for tomorrow as co-hosting. So she's like, you don't have to be on for the whole thing, but I mean, I'm going to want to watch it, I think. But I'm
Yeah.
just curious where you want me to fit in and what you would like me to do as far as that goes.
One of the presenters called me up. One of the attorneys called me up this afternoon and asked me the same thing.
Well,
He
did
was-
you
he was-
hear yesterday what happened on Miss G's show when Michael from New York called her? And so she
No.
told Stacy and who was the other girl? Oh, Star to take over while she took his phone call, but she didn't mute herself. So we all heard the conversation with her and Michael. It was kind of funny, but he was asking the same thing.
unfortunately, I found out either late yesterday or early today, he's not going to be able to be on the show.
Oh, no.
Oh no!
Yeah.
Really? Shucks.
As a matter
Wow.
of fact, I think it was early this morning. Somehow Grace got a message. Something came up.
Bummer.
Life always comes up and gets in the way.
Yeah, but he was supposed to be the first one to come on and be that firecracker, I thought. He should record something for us so we can at least play him.
The best slate. But maybe we'll start off with several of his TikToks. Hey, Grace.
There you go. Yeah,
Grace,
that's a good idea.
grab some of his TikToks and we'll play them.
Yeah. To get the crowd really amped up.
Yeah. Mr. Guai.
Yes, sir.
Any questions or comments?
No, yes, sure do. This is becoming like an overwhelming situation in this courts. Like the urine screen thing, and then we're seeing that they are dictating rules and laws and statutes and things like that. So when is the balance going to come? Is it the matter of the attorneys fighting the way that they are for over urine screens, or are they going to and is it just a screen or is it a test? Because here we go again, right? Like, okay, you want a urine screen, but what is a urine screen?
Right.
So,
I don't know. It's one of those things, like what are people going to do with the information that we give them tomorrow? Corey Okorocha, the testing expert, is going to be on tomorrow. I think he's on in the afternoon, and he's going to lay it out for us.
mm-hmm.
And if you guys wanted to be, on with his segment, come prepared to ask him questions, because people will be watching. They won't be asking questions.
Right.
They're going to rely on you to ask questions.
Okay.
So if you want to get some information, and Corey's the kind of guy he loves to answer questions. He loves to talk about what he does. We're friends on social media, and he always posts transcripts of him testifying as an expert in a case. And today he posted one. I hope I get this right. The district attorney, he's sworn in as an expert witness for the defense. The DA says, did you call and speak to the lab where they did the drug testing? And Corey's answer is, and I hope I get this right. Corey's answer is, no, why would I call and speak to someone at the drug testing facility? That would be like you asking your legal secretary for a legal opinion. I mean, but the guy's sense of humor and the way he answers
Yes,
things,
and
I
the way
mean,
he says it, he kind of gets you
yeah.
though.
If you go to if you search him on social media on Facebook, look at some of the posts of actual transcripts that he posts, because criminal cases aren't confidential, and he testifies a lot in criminal cases involving drugs and alcohol testing, and they're just hilarious.
Mhm.
They're just hilarious. So anyway, he's going to be on tomorrow afternoon. His segment for me is going to be worth the price of admission alone. So
Oh,
get
heck
some
yeah.
get some good questions to ask him, because he
Mhm.
will ask them. He will answer them for us. Okay.
All right.
Anything else, ladies and gents?
I think a lot of things that people are scared of with these whole like drug screening and drug tests, meaning I get the point that they're afraid that they might come back altered or false positive. Therefore, they think they're immediately going to not get their kids back. But I think you've mentioned it once before that just because, let's say that they do have a positive drug test or drug screen, even if it's truly altered or not necessarily is that going to mean that they're going to use that and not get their kids back. Maybe then they'll offer more like drug counseling services or this or that. But your biggest thing I think that you want to stress to people is you not doing the drug screen is what's going to prevent you from not getting your kids back. But if you do the drug screen and let's say it comes back dirty, that doesn't necessarily mean that they're going to use that and say, okay, well, now you don't get your kids back, right? I mean,
Wrong.
you said it's not like, oh, okay.
The way I guess the environment is now, people call drug screens tests.
Mhm.
Okay, they don't even make the differentiation.
Mhm.
I just did a case a couple of weeks ago, and it said that mom had a positive drug test at the hospital. And I remembered something Corey said. Most hospitals don't have drug testing laboratories.
Mhm.
So what they're doing is a drug screen.
Mhm.
Well, after the hearing, because I got the paperwork that day, nothing I could do. But after the hearing, I call up the hospital and I say, were these, and, after being on hold for an hour, I actually talked to
Mhm.
someone. I said, my client had this, blah, 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 and it came back positive. Was that a test or a screen? Oh, that was a drug screen. We send our testing out.
Mhm.
Well, did you send testing out on this lady? Blah, blah, blah. No, we didn't. Cost money to send it out.
Yeah.
We just go with the drug screen.
I think what I was trying to say though is okay, let's say it is the right way, the test, not the screen, the test. Let's say if they did test and it came back positive, meaning they had drugs, or if they didn't have drugs but it came back positive, could that be still an excuse for the judge to keep the kids from going home because it was positive? Is what I'm
Yes,
trying to ask. Oh, okay.
yes. But here's the big but. That's when you want a Corey to come in and look at the testing procedures. Because when he was on, one of the things he told us was for meth, there's
There's
this
two
final,
different, yeah.
there's this final step you have to do. And if you don't do that step, your result, your drug test result, probably is inadmissible. And he also said, I hope I don't misquote him, that most testing facilities don't have this machine to do this test because it's so damn expensive.
Mhm.
Yeah. I remember him saying that.
Can you imagine? We're just going to take the test. We're not going to use that final machine, and we're just going to tell the court you tested positive.
Yeah.
I can't tell you how many times throughout my career people have told me, they said I tested positive. Mr. Davis, I don't do drugs. Or here's another one, kind of funny. Mr. Davis, meth isn't my drug of choice. I don't use meth.
Yeah. Meaning they picked the wrong one to accuse me
Right.
of.
Now, had they tested me for heroin, okay, that would have been a different story.
Yeah, right.
Meaning, how
Right.
much more can that person be honest that it is an altered test?
But I mean, that's funny. But think about it for a second. They tested him
Yeah.
positive for meth, and he doesn't do meth.
Yeah.
He does heroin, but not meth.
Oh, Lordy.
Right. So there was something wrong with the testing procedure, obviously. Right.
They classified him for the wrong one.
Right.
Yep.
That will be known as a false positive,
Oh shoot.
scientifically
Yeah.
speaking. Anyway, so tomorrow, I think we start at 9 o'clock. We'll
9.
be going live on our Zoom. Unfortunately, there will be no show tomorrow because we will be doing the seminar. If you're interested in seeing the seminar, contact by email Grace, or there's a link right here at the bottom at calendly.com/VWD consultations. You go there and you can buy your ticket for the Zoom seminar tomorrow.
Do you know how many
Okay.
people have already signed up so far?
I do not. Grace would
Oh.
know. Grace would know.
Oh.
So
I was just kind of curious.
I don't know. It's the first time.
Am I logging in as the same way as I would log into like something like this? Like I'll get an email from Grace, or
You know, I don't know. I'm sure we both
Okay,
will be
I'll ask
contacting
her.
Grace about 8:30 a.m. tomorrow.
Okay.
Grace, what do we do? We won't worry about it until tomorrow.
all right.
You know, the good thing is we have all day Saturday to figure it out.
Right. Play as you go. Play as you go.
All right, folks. Everybody, thank you for watching. Mr. Guay, Ms. Payne, thank you for co-hosting. And I hope to see everyone tomorrow at 9 a.m. on our Zoom seminar. All right. Good night, all. Bye-bye.
Good night.
Good night. Have a good night.